This is a brief explanation of the 2014 Supreme Court of Canada decision for the Tsilhqot'in Nation. So this was the first time in Canada that Aboriginal title was declared to exist, and as I'm speaking to you in May of 2021, it's still the only time. It's an important precedent because it tells you how a First Nation can regain ownership of their ancient tribal territories. So at some point, many other First Nations are going to follow this lead, but the Tsilhqot'in are still the first. Tsilhqot'in, spelled with a T, is the original way of pronouncing the word that's been anglicized as Tsilhqot'in. The Tsilhqot'in country is the area west of Williams Lake on that high, dry plateau in the interior of British Columbia. And the Tsilhqot'in people historically fiercely defended their territory against other Aboriginal nations, and even against settlers. In 1864, they fought a war called the Tsilhqot'in War. It's still the most dramatic time when there was armed conflict between an Indian nation and the settler population. But the Tsilhqot'in people chose to go to court to enforce their land rights. And the importance of the case is that it takes an idea that you hear talked about a lot. For example, you hear people talking about the unceded territories of a particular nation. It takes that idea and extracts from it what the actual legal remedies, the legal rights are with respect to these unresolved Indigenous land rights. And you know, there is a lot of talk in Canada, and there always has been. It's a familiar feature of Canadian law. You go right back to the Royal Proclamation of 1763, the founding document of Canada, and it talks about protecting the land rights of the several tribes and nations of Canada. But it was mostly talk and not very well enforced. And to take an up-to-date example, you take the United Nations Declaration on the Rights of Indigenous People. It purports to protect land rights, but it also is vaguely worded and difficult to enforce. Even though governments across Canada are adopting it in legislation, it's still going to be a difficult document to enforce. The difference with the Tsilhqot'in decision is that it takes that talk, takes those ideas, and turns it into a concrete, enforceable legal judgment. So as of right now, it is trespass to go onto the Aboriginal title lands of the Tsilhqot'in Nation unless you have their consent. They have the rights of ownership, just like any other owner, and they can enforce those rights and do what they want with their land. That is why the Tsilhqot'in decision is important. And I hope that's helpful to you. Thanks.